Two houses of the National Assembly this year have reconciled their figures. The two houses of the National Assembly this year have reconciled the figure for the MTEF. I think they finally got to a middle ground. You know, for the two of them. For the MTEF, but that wasn't the case last year. Last year they were both agreed, and they had the TIF with the executive.
No, when you say last year was 2013.
Yes.
Now that was when the discrepancies reared their ugly head last year. You know, the budget, the bill was submitted to them between September and October last year. The two houses started to debate. By the time we finished this interview, probing to the whys and wherefores of the debate, of the discrepancies, of the conflicts of opinion between the reps and the senators, you will discover that it's for the interest of the legislators. You know, when it is 75%, 75.5% as the senators insisted on dollars, I'm sorry. When it is $75.5, like the senators insisted on. Now, the difference is not, it will not be big. But when it is $76 or $77, correct. Now, you sell, it continues at say 100. The difference between $75 and $100 will be so much. Where do you think that difference goes? If it is $80, for example, you are too close to what is existing, to the $100 that they are selling one barrel for today. You are too close to it, so it will just be $20.
Let me take you to the judiciary.
So, yes.
Because of the time now. Already we know that they will be busy as well this year, and who knows 2015 as well. But this is a key year.
Yes.
Because of the elections coming, already have cases in court for the previous elections, Ondo, Anambra, Edo. Already, now that you talked about the fact that who knows if you are the originator, you cannot benefit, all those parts will also feature in the judiciary.
Yes.
Because I think some people have already gone to court about who can decide who properly or not properly moved from one political party to the other.
Yes.
Do you see the judiciary being able to rise up and handle these cases and dispense them in good time with justice being seen to have been done?
Yeah, that is one problem area that I have seen, because in setting an agenda for next year, we can only set an agenda for next year, not for this year. This year is the penultimate year to the election year, which is 2015.
But you will have a test case.
Yes.
People who are defected go to court. It's going to have an effect on 2015.
Those people who go to court, I mean, you're asking about the judiciary, and that's where I think the problem is. For example, sections 76, 116, and 132 of the Constitution on when elections should be held have been amended from 60 days to the election, or 30 days, not earlier and not later, from 60 and 30 to 150 to 120 in all the cases, both whether state houses of assembly or national assembly, and even the presidential election. Now, and then with 150 or 120 days, that's 3 months. To give time for the court to resolve all these cases before the swearing in. That's it. So it's up to the judiciary now.
This will be the test.
Yes, correct.
After that amendment.
Correct. Now this one is going to be the test case after that amendment. Now, when you refer to those people who may go to court over whose seat should be declared vacant, that's where the courts have to be very careful. They have to exercise extreme circumspection in taking a decision on this issue, because, like I've told you, even if there is a proviso to that section 168 and 109 of the Constitution, that provided the decamping is not as a result of a division in the party on whose platform the person was elected to office, I'm insisting on the fact that provided you are not a perpetrator, you are not a creator of the division, which you now think enables you to cross the carpet. When you have originated the division, and you now say, okay, now there is a division. So if there is a division, the Constitution says I can cross carpet, and you were the originator of that thing. You created the division so that you can now switch over to another party. The courts have to take a look at this. Yes, that's the point I'm making.
Wow.
Yes.
That's an interesting
point. So as far as I'm concerned, as far as I'm personally concerned, all those legislators who switched over to any party stand, but when I say stand, removed, I'm not saying that anybody should go to national, because we are governed by the rule of law and the due process of law. So it is the court that has to decide this one. Now, unfortunately, we are the least litigious human beings, I think, in the whole of this world. We are not the most. Oh yeah, the least, because we don't go to court. We want to say, yeah, this thing is family matter. Okay, let us look. I have not heard that this matter is already in court. It's only in respect of the governors.
Oh, it is. It is in court because it is in court because somebody actually raised it on the floor of the House of Representatives, and the Speaker did say that he cannot, take a decision on that because the matter was already in court.
Yeah, I mean that this matter of legislators switching. Yes. If it's in court, I should be very happy. I should be very happy, but I have not. I have only heard of the governors. And I just told you that there is nothing anybody can do about governors.
I think they got an order restraining the Speaker from, taking any decision on that. I don't know how it's going to play out, whether it's just a court order restraining him or if someone has been sued or,
from declaring their seat vacant.
No, nobody can declare their seat vacant. Only the court can do so. Okay. Only the court can do so. Otherwise, we'll be taking the laws into our hands.
All right. An interesting perspective. Mr. Chris Akiri is the chairman, editorial board of National Daily Newspaper, and also a legal practitioner. Thank you for coming on this morning.
It is my pleasure.